Ever heard the phrase, anything you say can and will be used against you? Does it mean that everything you say to the police will indeed be used against you in court? Let's start at the beginning. This phrase originates from the Miranda rights, a set of rights read to those being arrested in the United States. The full line goes, "You have the right to remain silent. Anything you say can and will be used against you in a court of law." This is often interpreted as a blanket statement, implying that every word uttered to law enforcement will somehow be twisted and used against you in court. But is this really the case? The truth is a little more nuanced. Yes, what you say to the police can be used against you, but it's not as simple as it sounds. The context and the method of obtaining that information are crucial. For instance, if you voluntarily offer information to the police, this can be used in court. But if the information is obtained illegally, such as through coercion or without reading you your Miranda rights when required, then it may be deemed inadmissible. Moreover, not just anything you say will be used against you. The information must be relevant to the case at hand. If you confess to stealing a candy bar when you were 5 while being questioned about a completely unrelated matter, the court isn't going to suddenly charge you with theft. In addition, it's important to note that anything you say can also be used in your favor. If you make a statement that supports your innocence, it can be just as valid in court as any statement that incriminates you. So, the phrase, anything you say can and will be used against you, is not a one-size-fits-all rule. It's a warning, a reminder that you have the right to remain silent to avoid self-incrimination. But it doesn't mean that every single word you utter will inevitably be used to convict you. So while it's true that your words can potentially be used against you in court, it's not as absolute and all-encompassing as TV and movies make it out to be. Scene script. Next up is the one phone call myth. We've all seen it in the movies, but is it true that you only get one phone call when you're arrested? This particular myth has been perpetuated by countless films and television shows. The dramatic scene usually unfolds something like this. A character, typically in a grimy jail cell, is granted a single, precious phone call. But how accurate is this portrayal? The truth is, the concept of a single phone call after an arrest is more fiction than fact. While it's true that individuals who have been arrested are generally allowed to make phone calls, the number of calls and when they can make them can vary greatly. There is no universal one phone call rule. In fact, the regulations surrounding phone calls after an arrest are largely dependent on the jurisdiction. Different states, counties, and even individual police departments can have widely differing policies regarding phone access. Some may allow multiple calls, others may restrict the number of calls or when they can be made, and in some cases, individuals may not be allowed to make any calls at all until they've been formally charged. Additionally, it's important to note that phone calls made from a jail or police station are often recorded and monitored. This is another aspect that Hollywood tends to gloss over. Anything said during these calls could potentially be used as evidence, so it's crucial to be mindful of what is being discussed. The one phone call myth is a perfect example of how fictional portrayals can distort our understanding of the legal process. While these portrayals may make for engaging storytelling, they can also contribute to misconceptions and confusion about our rights and the legal system. So the next time you see this in a film or TV show, remember that the reality is much more nuanced. Ever heard of the right to a speedy trial? Does it mean that the court is obligated to hear your case immediately? Let's dive into the truth behind this well-known phrase. Its roots lie in the Sixth Amendment of the U.S. Constitution, which assures defendants of the right to a speedy and public trial. But the term speedy here doesn't quite match our everyday understanding of the word. While it might conjure images of a swift courtroom process, the reality is far from it. The phrase refers to the principle that legal proceedings should be carried out in a timely manner to prevent undue and potentially unjust delays. It's about protecting defendants from languishing in a state of uncertainty, or worse, in jail, for an extended period before their trial starts. However, it doesn't mean that the gavel will fall the moment you step into the courtroom. The timeline of a trial is influenced by a myriad of factors. The complexity of the case, the court's schedule, the strategies of the defense and prosecution, and even the defendant's own request for more time to prepare can all contribute to the duration of the proceedings. In fact, the Supreme Court has never set a specific time limit to define what speedy means in this context. Instead, they evaluate on a case-by-case basis, considering factors such as the length of the delay, the reason for the delay, the defendant's assertion of their right, and any prejudice to the defendant caused by the delay. So, while the right to a speedy trial is an essential safeguard in our legal system, it isn't a magic key to an instant trial. It's a balancing act between ensuring a fair and just process and making sure that justice is served without unnecessary delay. So, while the right to a speedy trial is a fundamental aspect of U.S. law, it doesn't guarantee an immediate trial. So we've debunked some common legal myths today, but why does this matter? Well, let's take a quick recap. We've learned that anything you say can and will be used against you is only partially true. Your words can be used for or against you depending on the context. We've also debunked the one phone call in jail myth. In reality, the number of calls you're allowed can vary widely. And let's not forget the right to a speedy trial, which is more complex than it seems, as it doesn't necessarily mean instant justice. Understanding these legal truths is vital. Misconceptions can lead to misunderstandings, and misunderstandings can lead to potential legal problems. The law, like life, is not black and white. It's complex and nuanced, full of shades of gray. Remember, the law is complex and nuanced, and just because something is commonly believed doesn't make it true. Always seek professional advice when it comes to legal matters. That's it for today's legal myth busting. Stay informed and stay safe.